So we have an NDA, non-disclosure agreement. It's a big deal, a non-disclosure agreement. Totally honorable, totally good, totally accepted. Every company has non-disclosure agreements. But the press called it slush fund and all sorts of other things. Hush money, hush money. It's not hush money. It's called the non-disclosure agreement. So it's not hush money. It's a non-disclosure agreement, totally legal.
I'm going to be sitting down with former President Trump later this week and asking him a lot of questions about this. And as former President Trump was just saying, voters don't have a right to know what candidates' skeletons are. And if they can keep their skeletons hidden, they're not committing a crime. This is not about morality, it's about legality. Everybody puts their best foot forward. Every politician puts their best foot forward. They don't come out and say, I've got a brother that's an idiot. I've got a this or that. They don't lead with those things. We all know that. It's not a crime to have an NDA or pay hush money, which sounds smarmy, and maybe it is, but it's not illegal. You talked about skunks in the jury box. What do you mean skunks in the jury box?
Well, a skunk in the jury box is evidence that should not have been admitted. And in this case, there were several things that stunk because they were skunk-like. The first stinky thing was that Michael Cohen had pled guilty to a variety of criminal charges, one of which was violating the federal election laws by paying Stormy Daniels. That was utterly inadmissible for the purpose of using it as the prosecutors did, which was to say, well, if Cohen did it, so did Trump, because Cohen was paid back by Trump. So they put it in evidence saying, this is a legitimate thing for us to use as prosecutors because it undermines the credibility of Michael Cohen. But the prosecutors were vouching for Michael Cohen. They were not trying to undermine his credibility. They were trying to make the jury believe him. The judge let it in, and the prosecutors then abused it by saying what I just said. Well, if Michael Cohen violated the federal election laws, and it's an established fact, said they argued, that he did because he pled guilty to it, then so did Trump. That was a big skunk, and the judge tried to take the smell away in the jury instructions by saying Cohen's a guilty plea doesn't mean Trump's guilty. But the skunk stink was still there after that instruction. You can't unring that bell. That's one. Two, there were these other tales of hush money payments, one to a Playboy centerfold, one to a doorman, to keep quiet stories about Trump that were salacious and embarrassing. The judge shouldn't have let those in. He did, but they had no probative value. This is a question about falsified business records. What does Trump's engagements with a Playboy centerfold or whoever the doorman was talking, what does that have to do with falsified business records? Nothing. I think nearly any judge would have kept that out. This judge let it in, and it stunk.
And didn't this judge also say to Trump, if you take the witness stand, I'm going to let them cross-examine you about E. Jean Carroll and defamation claims and the contempt charges and a whole lot of other things that had nothing to do.
And the $450 million civil verdict that Letitia James got. The judge said, you better not. If you take the stand, Mr. Trump, I'm going to let them at you on stuff that hadn't got anything to do with this case. Trump didn't take the stand.
Although he didn't say you better not. You know, a judge can't do that. He gets in trouble for saying that.
Well, that was a clear message.
Yeah. All right, coming up, why wasn't this 12-0 verdict unanimous? Because you had to have a 12-0 verdict to get to a guilty standing, but was it 12-0 on everything inside the verdict? Now, it's been said there were actually death threats against this judge saying that he didn't require a 12-0 unanimous verdict. Did he or didn't he? It was 12-0 on guilty, but what about inside the charges? We'll talk about that next.
is really at the fault of Judge Merchan. You have a situation where the actual federal crime about the election was never really identified anywhere through the trial, except at closing arguments by the prosecution. You didn't allow an FEC lawyer, one of the top people in the country with knowledge of how the Federal Election Commission actually works and looks at cases like this. They were not allowed to testify in open court in front of the jury. I think a lot of people are looking at this case and they see it for what it is. It is a sham. This was a railroad persecution of Donald Trump simply because Alvin Bragg and a lot of radical Democrats in our country wanted to get Donald Trump.
Are you ready to jumpstart your health in 2025? Lumen can help. Lumen is the world's first handheld metabolic coach. It measures your metabolism through your breath and via the app tells you whether you're burning fat or carbs. It then provides tailored guidance to improve your nutrition, workouts, sleep, and stress management. Start your day by breathing into Lumen to check your metabolism. Based on your results, it gives you a personalized nutrition plan for the day. You can also use it before and after meals or workouts to understand how your body responds in real time. Your metabolism is your body's engine. Optimizing it can lead to better energy, easier weight management, improved fitness, and more. Take the next step towards better health. Visit lumen.me/Dr. Phil for 20% off your Lumen. Well, tonight we're discussing the Donald Trump verdict, which I consider to be a judicial travesty. I think people have differing views on that, but I think this was something that was predicated on false business records. And actually, those records may have been false, but if they were, that statute of limitations had expired on those records, and they were regarding something that was not illegal, which was paying for a non-disclosure agreement with somebody that had a negative story about President Trump. So were they recorded properly or not? I don't know. Each one, the way they got to 34 claims was each time, each month, something was listed. There was a check and an invoice and a ledger entry. And so that was done each month, check, invoice, ledger entry. And that was 3 times each month. So each one of those was considered a felony. And so they multiplied that up. And
that's what we refer to as overcharging.
Yeah, that's what it could have been one charge,
Could have been
right?
one charge, yeah.
But they came up with 34 because it made for a great headline, 34 felony convictions. They also allowed Stormy Daniels to go into salacious detail about this alleged sexual encounter. That had nothing to do with business records.
Another skunk.
Another skunk, but they let it in. And that should not have been admitted. That should not have been allowed. It had nothing to do with the charges. It just made the jury look at him negatively. It was more prejudicial than probative. Would you agree with that?
Well, I think that's definitely a weighing that needs to be done in that case because a lot of information came out. She kept talking. The prosecution said, look, the defense got up and in the opening statements denied that the affair ever happened. That's why she was able to get on the stand and the judge allowed her to go on in so much detail. And then it allows the prosecution to say, look, while it was graphic and it was cringeworthy, those are the reasons why Mr. Trump didn't want it coming out before the election. That's why it was so important for him to be able to stop it. That's what the prosecution's argument was.
But the problem was that whether it happened or didn't happen had nothing to do with the crime alleged, with falsifying business records.
Well, the prosecution would argue it goes to the intent, right? There's always the intent element. There's the falsification of the business records with the intent to commit the second crime, which was the election interference. That's how the prosecution is allowed to bring in all this extra evidence, is it's going to show the intent element that they had to prove.
Well, let's talk about that second crime. So what was the second crime? Actually, they never specified what the second crime was, did they?
Until the trial.
Well, actually, at the trial, they said it could actually be violating New York election law, violating federal election law, or violating federal tax law. Take your pick. It could be any of these three.
Well, I think it was a little bit more specific than that. So you had the falsifying of the business records, and then you had to have the second crime, right, that was going to make it. The second crime was specified as the New York State election law violation. Under that, you had to show it was done by unlawful means, and that's where you get to the three options. So there's actually a sort of a three-part thing. And the first, you had to be found guilty unanimously, which is the falsifying of business records. The second crime, which is violating the state election law, had to be unanimous. But the three options of the unlawful means did not have to be unanimous. And that was confusing to many people.
Rod, you say that this coming down to three different things for unlawful means is going to be a problem on appeal for the prosecution.
Yes. Let me begin by saying, I don't know if you followed what this description of what the prosecution did to give the jury these three choices. I read that charge. It's 55 pages long. If I had been in the jury room with that charge as a lawyer, I would not have been able to explain it to the jury. It was so circular and so convoluted that it only can be described as we just heard, which was confusing to me. But here's the problem with giving them three choices. The jury must convict by a unanimous verdict. But the judge said, you don't have to agree that election interference or tax violations or federal campaign law violations, you don't have to pick one of those and agree on it. If there's one of them that some of you agree on and some of you agree on another and some of you agree on a third, but you don't agree with each other, you can still convict if you got 12 votes that he did something wrong. That verdict was not unanimous, and it had to be.
So we just want to say we've got about 1 minute.
Yeah, well, due respect, the jury instructions said you must conclude unanimously that the defendant conspired to promote or prevent the election of any person to the public office by unlawful means. You need not be unanimous as to what the unlawful means are. That's where and that is done in criminal trials all the time. They get options. Under felony murder rule, you can be held liable for a murder when they're not sure who fired the killing shot. So options are given to juries in different criminal cases. Here, they did have to find unanimously on the falsified documents. They did have to find unanimously on the second crime, which is the election interference. It was the options of deciding the unlawful means that they did not have to be unanimous on. They just had to pick one. They had to at least have one, but they didn't all have to have the same.
Mm-hmm. All right, final questions. Do you believe this case will be reversed?
I do, undoubtedly.
You don't think it's a close call?
I do not. Now, I don't know the New York Court of Appeals, but
That's the issue.
in Texas, out of here.
Yeah.
And if not at New York, it'll go to the federal. At some point, do you believe it will be reversed?
I think there are a lot of grounds of appeals. I think that the New York appellate courts are notorious for not granting a lot of appeals. I think it's 4% or something. But if there's a federal issue, it can get to the Supreme Court eventually.
Do you think it should be reversed?
You know, that's a very difficult question. I only look at this legally. I don't look at it from the outside. I think legally, it probably shouldn't have been filed in the first place, but appeals are based on the transcript of what actually happened in the courtroom. And so they can't look at the things that we've been talking about, whether it should have been filed or not. I think there are some novel things that happen in this case, that there are grounds for appeal, whether it should be or not. It's just a sad day. I think it's a sad day for our country that we have this conviction out there.